I'm just going to do a very quick piece on shareholders agreements. First, I'm just going to show you a very, very simple, basic corporate structure, the sort of thing you might expect to see on a deal. That's actually a quadruple NewCo structure for a management buyout. So that's where you might get to one day. Okay, so actually, that's you down here. So you don't need to worry about the rest of this. But I just thought I'd show you where it can get to, how structures can sit, where debt sits at different levels, where investors sit, where management sit, where loans sit. So this is kind of a really long-term view of where corporate complexity to get to and what can be structured in a lot of the documents that we do on the larger private equity transactions in particular. But this is not where you guys are at the moment. This is kind of something to aim for and then to get your heads around. So a deal like this would, because of the way they work, you would end up with something in the region of 250 to 300 documents on the table to be signed. And of those, there might be multiple copies of some of them. And of those, a lot of them have multiple signatures on them. So you can understand why a signing ceremony for something like this might take all day. And it literally does take all day. But what you're trying to do is get towards that at some stage in the future. And the best way to do that is to not mess things up now. Get your shareholders agreement sorted in the first place. Shareholders agreements are for the bad times only. I have lost count of the number of times people have come to me and said, I need a shareholders agreement. And I said, right, you need to tell me what happens in all of these scenarios. And they say, oh, we don't need to worry about that because we're mates. We're never going to fall out. Or we're family, even better. We're never going to fall out. But you know what? The only time we see people falling out in these scenarios is family and friends. It's the worst. So shareholders agreements are there to deal with what happens when something goes wrong. There's no point spending hours and hours drafting up all nice stuff about this is what my job's going to be and this is what your job's going to be and this is how we're going to run things on a day-to-day basis, because that's what you're going to do anyway. The shareholders agreement is for when things start breaking down. How do you deal with it? Because under corporate law, there is no way out. If you're two 50-50 shareholders in a business and you don't have any shareholders agreement or very, very specific articles that deal with this, and one person says, I'm off, I can't work with you anymore, they are completely and utterly entitled to keep their shares. And you're then there working on your own to try and grow a business where someone else is getting half the benefit and they're not contributing at all. So getting that into the documentation while you're still friends is really, really important. And you have to put yourself in, wear two hats doing this. You need to put yourself in I'm the person at the company. What would I want to be the position if someone was to leave and there was a fallout? And the other one is obviously if you're the person falling out and you're the person leaving, what is a fair treatment? There are lots and lots of different terminology about shareholders agreements, but they fundamentally fall into three categories. There's the agreement of equals, which is where you have co-founders of a business, for example, where 2, 3, 4, however many of you get together to start a business to run it. And that's the kind of your standard shareholders agreement that most of you will be interested in. You then have what's often known as an investment agreement, or you might see subscription agreement, or it might just be called a shareholders agreement, where you have a third-party investor who's not necessarily going to be involved in the business, but is putting in cash, potentially know-how, potentially access to facilities. But that is very much where they are in a dominant position as the person holding the purse strings, but they're not running the business. So they want to control how that money is spent, essentially, and how they can stop you from doing something stupid with it. The third one, which is probably less relevant to this, but could be in a separate scenario, is a joint venture agreement. And that's where two bodies or parties come together to work on a specific project or to work with a specific asset. So one of you guys might have a really clever piece of tech and, dream scenario, Google come along and say, I want to work with you with your piece of tech to develop a new product, and we're going to work as a joint venture, and you'll own half of it and we'll own half of it, and we'll pool our resources to create this specific product which we'll then market as a joint venture. So that's a kind of separate one, and is more, and that can be done as from a shareholding perspective, or it can be done at a purely commercial level as an agreement. But it's normally done with what we call an SPV, a special purpose vehicle, incorporated for the purpose of doing a specific project. As I say, the best types of agreements are the ones you never need to look at. So if you never fall out, you'll never get that shareholders agreement out the drawer. It'll sit there, and then you get it out the drawer and realise someone's not signed it, which is what Emma was talking about earlier. So, as I said, the least important bits are talking about what happens in the good times. The most important are dealing with the bad times. And every agreement of equals has started with people telling me we don't need to worry about that. Had it very, very recently on something, and 2 months later, literally 2 months later, they'd fallen out and were trying to work out how to split things up. Luckily, we put something in place that dealt with it. So the key clauses to go into standard shareholders agreements, and a lot of these apply equally to an investment type agreement as to an agreement of equals. So reserved matters. These are a list of matters that a single person does not have authority to do on their own. So these are the big decisions where someone can't go off and sign a new lease of some premises, or sign a big contract that ties you in for 2 years, or buy some big asset that they're not entitled to do. So these are things that say any decision around this list of matters has to be made either at board level or potentially at shareholder level. Now, in a lot of small companies, the board and the shareholders are the same people, but they might not be. So you might have some passive shareholders, but they're saying, look, this is my money. If you're going to go and spend £100,000 on some piece of equipment, I want at least a right to know about it and to have a potential veto on it. And the reserve matters can be, you can say these matters need at least 75% of the shareholders to approve them, or you could say they need 100% of the shareholders to approve them. You can set that, and you can have both. You could have multi tiers of reserved matters to say these are less important, so we just need more than 50%. These are really, really fundamental. Everybody's got to be on board for us to go ahead and do something like this. So there's a fairly sort of well-trodden set of reserved matters, but then how you divide that up into things you consider to be absolutely fundamental and things you consider to be less fundamental is a matter for discussion and negotiation. What that means is that somebody isn't going to go rogue and go off and do something and say, well, I didn't know, I wasn't allowed to do that. Drag and tag. Now, this actually generally sits within the Articles of Association within the Shareholders Agreement, but really we're talking about the two documents as a package. Drag is how you deal with minority shareholders who are being difficult. Let's say you've got some guy who owns 5%, and he came in, and someone else comes along, Google again, comes along and says, we want to buy your company and we're going to give you £10 million. And that 5% shareholder goes, nah, don't want to sell to Google, I don't like them. I disagree with corporate whatever, and I don't want to sell to Google. If you can't bring him along, you can't sell the company. Google aren't going to buy 95% and go, it's all right, we'll keep that rogue guy who hates us owning 5% of the company. Not going to happen. So that person can scupper the entire transaction. So what you want is drag along rights. What those say is if more than X% of the shareholders, and that can be any number, want to sell the company, everybody has to sell the company. I have seen shareholders agreements where it literally said that. If the majority wants to sell the company, everyone will sell. Completely and utterly not enforceable, not good enough. It needs to be backed up with the right wording in a legal document. The shareholders agreement needs to contain a properly executed power of attorney which allows the majority shareholders or someone nominated by them to execute the documents on behalf of the difficult minority so that their shares can be sold on their behalf. A power of attorney has it's one of the relatively few legal documents that has a special where it has to be executed as a deed. That execution has to be witnessed. So getting that right in the shareholders agreement is really important, because if you don't have it, you can say, I've got a drag along, right, and you've got to sell your shares, and he says, tough, I'm not doing it, and you go, I'm going to take you to court. What you want to avoid is any scenario that involves you having to go to court to enforce. If you build in power of attorney that says, if you don't sign, I can sign for you, then that's the way to deal with it. So that's a really important one, and that's something we see all the time with minority shareholders holding the majority to ransom because they say, well, I'm not going to sell, so make me sell, give me some more money. Tag along is the kind of the other side of that coin, the flip side, which says that 5% holder, you can't have someone who owns 60% going, oh, Google have just offered to buy me out, I'm off, see you, bye. Tag says the remaining shareholders can go, whoa, 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 you can't sell yours unless they buy mine as well, because I'm not being left behind into this scenario where I'm now a minority shareholder for some corporate conglomerate who's not even going to listen to me. That's not what I signed up for. So tag along enables minority shareholders to exit when a majority shareholder exits. And if you're starting off as a 100% owner of a business and you're slowly diluted as you bring in external investment and you bring in more and more investment, so that suddenly you find yourself as the minority and then the majority investors go, we're selling, and you don't want to be left behind. So it's important to protect yourselves from that perspective. Disputes and deadlock. Now these are more relevant to generally companies where you've got 2, 3, maybe 4 shareholders and you've got a situation, potentially might be one of the reserved matters, where you've got 3 people saying, we want to do this, this is our direction of travel, and the 4th person, 25% shareholder, saying, no, this is completely the wrong thing to do, I completely disagree with you. Now, can you carry on a business where you've got 3 saying one thing and 1 saying another, and you've got a complete deadlock situation? Not really, it doesn't work in that scenario. So what you need is a mechanism to work through that. You will normally have some dispute resolution wording in there. It's quite soft from a legal perspective, so you'll normally say if the shareholders can't agree it, and let's say you've got a corporate investor, then maybe instead of being the chief exec within one of the shareholders, you'll go to the chairman and you'll try and escalate the dispute to try and get it resolved. But the fact is, you've probably already done that already, and if you've fallen out, you've fallen out. So then you go to a deadlock scenario, and what that does is it creates a means to exit a shareholder or a group of shareholders. There are all sorts of silly names for it, like Mexican shootouts and all sorts of things, but fundamentally it is a way of saying one of us is going to have to go and we're going to have to work out a way of doing that. So there's various ways of doing that. You can have blind bids for the company. So you say, so let's say you've got 2 50-50 shareholders is the easiest one to envisage. And each one puts a bid in, says, I will buy your shares for £1 million. And they say, I'll buy your shares for 1.2 million. And whoever bids the most gets to buy out the one who's bid the least. It's a pretty obvious way of doing it. Sometimes you do it so that the one person who may be the one with the deeper pockets puts the bid in and says, I'm prepared to pay £1 million for your shares. And then the other party can either then choose to buy or sell at that price. So it's their option then at that stage. They can say, yes, that's a fair price, therefore I'm going to sell, or actually that's too cheap, so I'm going to buy yours, if they can fund it. The ultimate, and sometimes you may not have the funds to buy the other person out, and therefore the only realistic way to do it is to wind the company up and effectively dissolve the business, which is never the ideal way of doing it. But what you can do in that scenario is one party can end up buying it from the receiver in a sort of pre-pack or an insolvency package. But having something in there that sets out what happens in that irreconcilable dispute is really important, because the default is one person applies to dissolve the business and then everybody comes out worse off. You know, there's very little value in the business in that scenario anyway. Levers. This is so important. I mean, my first thing to say would be, if you can get away with not giving your employees shares, then don't give them shares. There are ways of giving them equity incentives that does not involve them being shareholders. The best way of doing it is through some sort of tax efficient option scheme. There are things like EMI options, which are really great. But if you're to say you're going to have shares, what you do is you set up a nominee arrangement. The nominee company owns the shares. The employees own only the beneficial interest in the shares. The tax treatment of that is identical to as if they were the registered owner, but if they leave, you can automatically take that beneficial interest back off them. If they are the registered owner, you've got to go through all the rigmarole of getting them to sign stock transfer forms and registering at a company's house and paying stamp duty and all this sort of stuff. It's a real pain, and people are very, very eager to dish out bits of paper, share certificates. You can do it in a way that gives exactly the same benefit and does not create so much of the hassle for you. But if you do have people, and it might be that they're one of the founders alongside you who are shareholders, and they decide, you've not necessarily fallen out, but someone gets, I've seen this happen, someone suddenly gets a job offer from a really big one that massively is right in line with their skills, and they're like, I'm really sorry guys, I've got to take up this for my family, for stability, whatever. I'm going to take this job offer. You again don't want to be leaving that person with their shares to then benefit from all your hard work in growing the business. So you have what's known as leaver provisions, and you can have good leaver, bad leaver, intermediate leaver, and all of these terms don't have a fixed meaning. It's an infinite rainbow of ways you can treat these different categories of people. But as a general rule, think about how you would like to be treated in that scenario. Some people say the only good leaver is a dead leaver. What that means is if you get hit by a bus, is it fair that you lose all of your value in the company and your family gets nothing? Well, probably not. In that scenario, you can either say the family gets to keep the shares and benefit, or the other shareholders or the company will buy those shares out at their fair price, what their market value is today, which is to take the market value of the company. Let's say the company's worth $1 million, they own 10%, so they get £100,000 for their shares. That's a good leaver. And a good leaver can also be someone who retires at a proper retirement age, or someone who is very ill, who gets cancer and has to give up work, for example. Then you can have bad leaver, would normally be someone who has done something naughty, has been sacked from the company. It could be someone who's just resigned, who's just chosen to walk away. And it could be someone, it could even just be someone you've decided to remove because they're underperforming. But then again, you might treat them slightly differently because you're saying, well, that's your decision. In a bad leaver situation, you might say, well, hang on, I gave you those shares because you are going to be there on this journey with me. You're not, therefore you lose them. And you lose them for their par value, let's say. So let's say your par value of your shares is £100. So in that scenario, market value might be 100,000. Sorry, you're getting £10 for your shares. They come up because I've now got to go and find someone else to do that role that you were going to do, and I need to be able to give them those shares in order to motivate and incentivize them to do it. So that's leaver provisions, and as I say, in between those two extremes, there's an infinite way of. So you might say, well, if you last for 2 years, then you can get 50% of your value, and if you last for 3 years, you might get 60% or 70% or whatever. That would be a sort of generally called an intermediate leaver scenario. But it's about recognizing that you are not a PLC. Your shares are not tradable shares. You can't just go and say, I'm going to sell my shares and the market price is this and I can sell them. You're a private company. The value of shares is inherently in the people. It's in the sort of the fact that you're all there pulling together. And the fact that someone leaves, they should not either A, be able to keep their shares, and B, get full value for those shares. And finally, restrictive covenants. Now, Laura mentioned restrictive covenants earlier in the context of service agreements. Those are okay, but frankly, restrictive covenants in employment contracts are of limited enforceability. For the reasons Laura said, you can't stop someone from earning a living. If they're a programmer, You can't say to them, you can't have a job in programming. It's really, really difficult to put that, and especially in an employment law contract. An employment tribunal will say, no, sorry, that's unenforceable. They've got to be able to go and do their job. In the context of a shareholders agreement, they're much more enforceable. Because you have entered into that business relationship that is not one of employer and employee, but it's of equals as shareholders, the courts will generally allow a higher level of enforceability of restrictive covenants. So you can get away with having a longer period, and it's linked to their share ownership rather than their employment. It could be linked to their employment, but it can also be linked to their share ownership. So you can say, while you're a shareholder in this business, you can't compete with this business, and actually for 12 months, possibly even 2 years after you cease to be a shareholder in this business, you can't compete with this business in the same way. So having those in a shareholders agreement as well as an employment contract is a really, really good idea because they're much more enforceable. Where you've got investors in, they will always want to have the ultimate say on key issues. So we're talking about reserved matters. Investors will have reserved matters that says you cannot do this without us, and it doesn't matter if they own 5%, 10%, whatever, they're going to have a list of things where you're going to always have to check with them. And it may be you send them an email going, we're going to do this, and they come back and say, yeah, it's fine. But bear in mind, what you don't want is something where you can't blow your nose without getting the investor's consent, and if you did it, you're technically in breach, and then they've got this power over you. So make sure you set those thresholds appropriately for your business so that you can run it on a day-to-day business basis in line with your business plan. And a really good way of doing it is saying, anything that's in our business plan, we don't need to get your consent for, because that's already been approved. And the other thing I would say is, a lot of founders in small businesses will do a rudimentary shareholders agreement and think that's it. Think about getting employment contracts as well. Most founders I come across don't have employment contracts because they're like, well, it's my business. Why do I need an employment contract? Well, you've got to wear those two hats. You're a shareholder and you're an employee. You're an employee of your own business, and you won't always be the 100% shareholder possibly. So having that in place early on is good for due diligence. People know what your terms are. It's good for your own protection, even when, I mean, I don't know if you guys have heard of Kettlebell Kitchen. She's just been ousted from her own business that she founded. And it's very sad because she allowed herself, she gave away too much power to her investors to the extent when they decided they didn't need her anymore, and she's out. That can happen, and it does happen. You know, investors are there to make money. They're not there to because they've got a social conscience. So think about that early on. If everyone else is getting, yours can be exactly the same as everyone else's, but just get one.